The past week here on the Hugh Hewitt Show, you've been hearing me discuss in detail one case, Foote versus Ludlow School Committee. It is a decision of the United States Court of Appeals for the First Circuit, which covers New England, Maine, Massachusetts, Rhode Island, Puerto Rico, there's one state, Vermont. And I just couldn't believe it when I read it, and I immediately sent a message to Kristen Waggoner. Kristen is the president and CEO of Alliance Defending Freedom. She's an old friend. Alliance Defending Freedom is one of the greatest legal organizations in America, and I've been pleased to know Alan Sears and Michael Ferris and to work with Kristen for many years. But I thought this was so outrageous I had to go to an expert. Kristen Waggoner joins me now. How are you, Kristen? Thank you for finding time for me.
Well, thanks for including me.
Kristen, would you explain to people what are the facts of this case and why the First Circuit opinion upsets me so and why it ought to upset parents?
I would be glad to. It involves a case with a sixth grade girl. She was 11 years old, and she was having trouble in middle school, as a lot of 11-year-old middle school girls do. And as she was struggling with self-image issues and just some of the things that happen during adolescence, she began to receive information that was advancing LGBT ideology, gender ideology in her school, and eventually told school officials that she wanted to be gender queer and wanted her name changed and pronouns changed and so on. The school reached out initially to her parents. Her parents expressed appropriate concern, helped her get help through counseling and other venues, professional venues, and told the school basically, thank you, we're her parents, we're getting help for her, and move on, essentially. Like, we've got this covered. What ended up happening was the school then continued under its official policy to transition her behind the back of her parents, and despite their explicit request that they not do so. So it's not only an issue of parental consent, but it's active deception of parents in the public school system. And I understand why it's causing you such grief, because it's unthinkable that that would happen. But I'm telling you, Hugh, there are about 1,000 policies in 1,000 school districts right now across the United States that have very similar policies. This is happening in 37 states. And we have a number of cases, so much so that we set up an entire parental rights team because of the threat that this poses.
You know, Kristen, when you told me that in our brief exchange on the internet, I was kind of stunned because I've been teaching con law for 27 years. I teach Meyer and Pierce, and it's kind of a short course. I tell them parents control the education of their children, period, end of story, let's move on. That's black letter law. When I read the First Circuit's opinion, they pretended to deal with that, but they didn't really deal with it. It was a mutiny. They basically ignored it.
Yes, they did. And we know that cases like Myers say that perhaps a document from 1923 forward, this is the oldest fundamental liberty interest that exists. But we have consistently seen courts and government officials narrow that to the point that it's not even a second-class right anymore. And this is despite the fact that we know parents know their children best and they love their children most. We don't co-parent with the government. There are so many stories that I could tell you, Hugh, about these cases and the way that these victims are being harmed. It's deeply disturbing.
Kristen, I'm not easily shocked, but I was shocked. The First Circuit opinion here, I don't know if you want to comment on this, I would reject it from a 1L. I wouldn't let them pass legal writing. If someone said, dear reader, gentle reader, or the kind of language they use to disparagingly refer to their judicial superiors, it's really a disrespectful, but it's two rookie judges and an Obama judge, and they signed it per curiam. Why do you think it's a per curiam opinion, Kristen Waggoner?
I maybe they don't want to. I don't know. I'm not going to speculate on that. This case is my hope is that it's going to go up to the U.S. Supreme Court. I think you're right to spot not only is the legal conclusion wrong, but the writing style, it's even disrespectful to the parents in the way that it's written.
Yes.
Almost from footnote 1, Hugh, you know where this is going. When they say they're going to use they and them for the child's pronouns.
Yeah. Now, let me ask, you've done a lot of litigating in front of the court. You're a very experienced constitutional litigator. Have you ever seen a court be so dismissive of the arguments of the other side? because they really don't deal with them.
I have seen them. In fact, what I would tell you is that on the legal analysis, on the substantive due process, which just gets into the weeds a bit, they're walking through, and in some ways they're correctly reciting some of the basic tests, but their conclusion is flat out wrong.
Yep.
And we know that there's a split in the circuits. We have cases right now in the Second Circuit, heading up to the Sixth Circuit, the Third Circuit, the Fifth Circuit, the 11th Circuit, the First Circuit. I mean, it's a big deal, and I do want to just make sure we don't lose the point here that secrets harm children. They don't help them, and the science actually is completely the opposite of what this court says it is. In fact, engaging in social transition of a child locks them into becoming a lifelong patient for the rest of their lives, whereas if you simply parent them, listen to them, talk to them, get them appropriate professional help, as these parents were doing, 80% of those kids live healthy and happy lives consistent with their biological sex.
And I want to point out the fact that the school district lied to the parents. This is, to me, the astonishing thing. If they wanted to tell the parents, we're rejecting your advice, we're taking over, they could have taken her out of the school. They could have gone to a private school. They might have been able to sue. But they lied to the parents. Is that routine, Kristen?
It is 110% routine. Hugh, they're following an official policy. We have represented many counselors and teachers and public school officials who have lost their jobs or been disciplined because they refuse to lie to parents. So even public school officials are being canned for daring to speak the truth. But let me tell you, there are a couple of stories of some of the cases we're dealing with. Amber's in Wisconsin. Amber, again, these are all middle school kids that are struggling. And her parents, she tells her parents that she thinks she's a boy. Her parents go to the school, try to work with the school, tell the school, stop treating her this way. They then again deceive the parents. Thankfully, Amber's parents pulled her from the school, and then they sued the school, and we won. Another example, though, is the Meade case. The Meade case is out of Michigan. Same thing, child struggling in school. They're working closely with school counselors, literally having regular conversations, and the school counselor is hiding it from the parents. And this has happened many, many times. And I'll just tell you, even under these policies, we have one case where a middle school girl was going on a field trip, essentially an overnight trip, and was told she needed to sleep in the bed with a boy who identified as a girl without telling her parents or getting their consent.
All right, so you're weirding me out. Can I keep you in front of the segment, Kristen, because I want to find out the status of the Ludlow case, Foote versus Ludlow School Committee, whether or not the cert petitions are being filed. And then I want to find out about the center that you stood up at Alliance Defending Freedom, because I think our audience will want to know about this, because if one school district is lying and 10 school districts are lying, you can just be sure that hundreds are lying. And I just didn't think I would live to see a day in America where you can't trust the public school system to at least tell you the truth about what they're teaching the kids. I'll be right back, and if Kristen can stay with me, she will be as well. Alliance Defending Freedom, look them up. They are a wonderful organization. They are the ACLU of the center-right in America, or what I call the normies. Kristen Waggoner is the CEO and president of Alliance Defending Freedom. She's been a guest of mine many, many times. I reached out to her after reading Foote versus Ludlow School Committee because I wanted to know, is this prevalent? And number two, what's going to happen in the case? Kristen, you told us about a new center you've stood up at Alliance Defending Freedom. If people want to help out, they can go to adflegal.org, adflegal.org. What's the center?
It's a Center for Parental Rights. At ADF, we have 5 generational wins that we work on. There are a lot of issues we can be working on in the law, but we have 3 top issues: gender identity, gender ideology, censorship, and parental rights, because those are where we see the most imminent threats in our areas. We have to get the court to again affirm the right of parents to be able to direct the upbringing and the decisions related to their children.
And Kristen, as you survey the field, you do have a good view of everything going on. From which circuit do you expect the case to get to the court, and do you expect a case like Foote to get to the court?
I do. I expect that there will be a case. I never can really predict which one. We have a circuit conflict right now, which is one of the reasons why the court would take a case, is if there's disagreement in the lower courts. that disagreement has been established as far as not only the outcome, but the way you get to a legal victory. And then, as I mentioned, there are at least 6 other circuits throughout the United States that are addressing this issue right now. I think it's also important for your listeners to realize that the Supreme Court has some cases this term and next term that are related to these issues that they've already agreed to take as well.
Now, are you optimistic that eventually 42 U.S.C. 1983 will, in fact, lie against school districts that deceive parents? Because it seems to me to be the only way to stop the deception is to make the people responsible for it pay.
I am, but I think that we have to take a much broader approach in thinking about what are the types of cases and what we need. There are legislative measures that can be put in place. We have a bill that we've proposed in Congress to ensure parental rights, but 33 states right now, Hugh, do not have protections for parents in their statutory law, and we can change that. And in addition, we know 100 jurisdictions right now have bans that prevent counselors from counseling minors who are struggling with gender confusion and helping them live at peace with their bodies. That case the Supreme Court just agreed to hear next term as well. And we have also we have 3 cases before the court this term that have been granted. And the second involves charter schools and the rights of parents to be able to have religious schools and other schools a part of the charter school program, so they have the option to pull their kids when this type of ideology is being taught and indoctrinating their children.
Now, Kristen Waggoner, this is not an issue that is decided by popular opinion, but I do believe it's not a 70-30 issue. I don't think it's an 80-20 issue. I think it's a 90-10 issue, that 9 out of 10 parents would say, the school owes me full disclosure and the school must do what I tell them to do on issues of this sort. Do you agree with my assessment of popular opinion on this?
I do agree with your assessment if you have the right questions asked and parents are informed, but I think we have a lot of parents that are a bit ignorant as to what's happening in the schools, and they're also unsure. We all want to lead with compassion, right?
Yes.
And so they're confused about what this means. Everyone should be treated with compassion, but the best thing that those with gender dysphoria can have is resolution to that confusion, and that comes from truth, and the science supports that. So it's time for the courts to catch up. It's unfortunate that the Supreme Court had a couple of opportunities to deal with this issue before these policies went into place and before victims were harmed.
We are always a step behind because I don't think we ever quite imagine that things can get worse than they are. I don't often talk about this topic on the radio because, of course, parents are in driving their kids home from school and that it's an uncomfortable conversation. But I believe that the public is aware and alert and that they are not they do not lack compassion for children struggling with gender dysphoria, but they do lack compassion for schools that think they're in the driver's seat. Have you seen any schools stand up and stand with the parents?
No.
It's just shocking.
Obviously, we're dealing with the troublesome situation, but when you think about that there are 1,000 schools that have these policies, 37 states plus D.C., and something like 12 million kids are falling under these policies. I will say that when we sue them, we are able to, win these victories, get these policies changed, and in addition, we have started working with some school boards who are affirmatively reaching out, but they have to have the courage to stand because, of course, they're going to be threatened if they adopt a counter policy. But you're right that, again, I want to reiterate, parents don't co-parent with schools. They know their children best and love them most, and we need to take responsibility for our children.
Well, thank you for all you're doing. Thanks to everyone at Alliance Defending Freedom. If you want to help in the fight, go to adflegal.org, adflegal.org. Thank you, Kristen. I look forward to updates as you get close to a cert grant in one of these cases. I appreciate your taking time with me today.